studio. Okay. Sorry everyone. I know this was incredibly short notice. That's just the way these things end up going. I just received an email from the court that the jury has reached a verdict. Um, yeah, the fact that it took this long, and presuming they came in at 9 o'clock this morning, they had an hour yesterday. Yeah, then an hour and a half today. Um, I think that does weigh in the realm of this is going to be not ideal for Mr. Swinney. Um, yeah, I'm not. I'm still watching to see how the. Why is my file not working? Sorry. I'm still waiting to see how they're going to announce this, but yeah, no, I haven't been able to bring up WebEx myself either. Um, I've had it set on an auto refresh, the page from yesterday, and it has not updated yet. From my understanding, when I spoke to the court yesterday, now that a verdict has been reached, they're going to have to call the attorneys who are going to have to come in. Now, Multnomah defenders um, are literally next door. Prosecutor's office, I'm not exactly sure where they are, but I don't think they're too far away. Um, Honestly, I feel like the longest delay may be in getting Mr. Swinney to the courthouse. Because he would need to be there, and if he's up at Inverness, um, I'm actually going to go ahead and I have just sent an email to the judicial assistant, asking if they have an estimated start time. Um, the way the conversation was going yesterday, I don't know that it really matters. It sounds like it's just that quick. Um, and that's why, before I did anything else, I went ahead and just got the stream up and running because I didn't want to risk them starting instantly and all of a sudden we're left behind the loop. Well, that's not ideal. Let's try. That's why it was failing me. Okay. Um. Okay. I actually the WebEx link just had some changes made. Um, it changed the date from yesterday's to today at 11 a.m. So that's in about 10 minutes. Um, let's see. Um, oh God, play witness testimony. I don't know that I have really anything ready that is that good. Um, yeah, I suspect he will still be at his table at the defense. Which of the um, because of the way the camera's pointed, I'm not sure that we're going to get that good of a view. And trust me, I mean, for just journalism, not even kind of Schadenfreude or anything. I would definitely like if he was like say sitting on the witness stand so we'd be able to see that. But I really don't expect them to actually try to do something like that. Uh, oh no, I haven't. I didn't get anywhere near that point. Yeah, it does feel like if anything, they just wanted to make sure that they were right. And I was in the middle of going through footage from the 30th, making clips to put up online, and all of a sudden I get a couple of dings, and then one of them's the email, and it's like, oh, whoa, holy crap. Um, so yeah, what's going on with WebEx is we are waiting on them to turn it on. Um, from everything that I'm seeing on the dashboard right now, it should be in the next 10 minutes or so. Um, that's what I can do. Window, no. Uh, display capture. That source. You are this one, yeah. Oh, oh, they actually just turned it on. Right as I was going to get ready, I was going to pull the only good short clip I had was the video of them tearing apart the one witness who was like, I only had a camera, and then all of a sudden we find out, oh no, he had a gun and he had pepper spray, and let's see here. Don't need that. That can stay up. We need to test. Really quick sound check. Okay. I mean, I don't know why he would. Um, I'm not entirely sure why he would end up suing Facebook, but yeah, there has been a verdict reached. We have not heard the verdict yet. That's what we're getting ready for. Okay, I gotta deal with that now. Yeah, I got completely thrown. Was definitely not expecting this early. Oh, they're doing the verdict down in Judge Moed's regular room, maybe. This is not courtroom 11A. This judicial assistant just telling me that she didn't know when the hearing was going to start, and then we find out, oh no, it's getting ready to start now. Okay, a theory that if Facebook had not been, you know, actively platforming this right wing content and uh, you know actually moderating misinformation like they said they were going to do, then maybe. Yeah, when I'm looking though, the clerk's desk is on the opposite side of the judge's stand, unless they mirrored the camera, but everything looks opposite in this shot from what we've been seeing before. The witness stand looks to be, when you're coming into the courtroom, the witness stand looks to be on the right side of the room. Um, Clerk's desk on the left side, and the where they were actually holding the trial, all of that was reversed. And they actually do have a lot of mirror designs, partly so that they've got an elevator system that's designated, for non-public use, where they transport inmates and things like that. Oh, yeah, that's a good point. Curious are pointing out that Facebook moderated him right off the platform. They actually said that after he, in one of his Parler posts, he said that after July 4th, everyone that had gone up to the Chaz flag wave had gotten their Facebook accounts terminated. Yeah, the camera right now it's one of the ones that's above the jury bench. Yes, the social media posts that were shown were from Parler. Presumably, I mean, there probably would have been inflammatory posts on Facebook as well, but once the account is suspended, the DA might have been able to subpoena Facebook to get archive records as evidence, but it really did have a pretty good um, case just off of the Parler posts, and not even all of them made it into the official record. Okay, so um, I'm going to be, once we figure out how they're setting up the cameras, I do have a different screen that I'm going to be using when we actually do the reading, where I've listed off all the charges, and we can mark them as they're read. That screen won't have the voice chat or the chat stream, but okay, I'm not sure. I'm not surprised that there's screenshots floating around, but when it's screenshots taken by another person, its admissibility as evidence becomes a lot more difficult because it's a lot easier to make a claim that they're altered or it's not me that made the post. Um, all this parlor stuff, this all happened before Amazon nuked Parlor, and they lost a lot of data, but the DA was able to capture that as using the proper rules of evidence. Oh, good, 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 good. Thank you. Let's see. Actually, I'll remove this one from the stage. I don't know if. No, I'm going to leave it on the stage. Sorry, I'm trying to figure out. Oh yeah, yeah. Video is definitely harder to fake. Not to say that it's impossible. It's just one of those really tricky things to try to figure out. Wrong side. Yes, yes, I'm hearing. Oh, okay. Yeah, I have someone who just sent me a link to some pictures and such. Yeah, I will admit the Skylar Jernigan case. I did not get a chance to follow. That one was open and shut so quickly that it kind of threw me there. Okay, yeah. See, the only thing I knew about Skylar was the actual the firearm shots. Oh, on the 15th. Yeah, because I think the 22nd was his charge for shooting the gun out of the car. Go ahead and tighten the view up a little bit. Yeah, that's one of the things, and that's actually been a like a criticism against Measure 11. I don't know if any of his charges were related to Measure 11 or not, but um, where it's discussed that it caused a disproportionate number of people to take plea deals specifically to avoid getting mandatory minimum charges. I had the enviable joy of getting to go through a lot of research last night because I wanted to try to get an idea of what kind of sentencing we could be looking at for different charges. And I will say right up front, Oregon's sentencing guideline chart is not that easy to comprehend. Oh yeah, yeah, and if you're going against the government, they're a lot harder on you than if you're just going against a person. Um, yeah, that shouldn't be a controversy, and yet somehow it is. Oh wow. Yeah, yeah. From what I saw, everything I saw was pointing towards 5 years, 10 months. There are some carve outs to allow for departure for mandatory minimums. Um, when I looked at the phrasing of the statute, I feel like one of the assault charges against Meg Stewart might qualify, but I feel like at the very least, Jason Britton, where him getting shot in the eye, and a year later still having problems from it, that one should get a mandatory minimum. So that's my theory, but it seems like there are so many caveats and workarounds and everything. I am beyond lost on that. Um, yeah, get this tab. So I'm going to go ahead and drop a link in the chat here. Um, that is not the link I wanted. Like I said, this was sent to me by somebody else. It's a an imager gallery of the screenshots that were mentioned in chat, and Yeah, a lot of these I can see not being admissible as evidence. Yeah, Nathan, when I was doing my research last night, it seemed like there was some case law. Like, I think one of them was talking about an assault charge where a person was assaulted with a tennis shoe, and the state had to prove that the how a tennis shoe used in that way becomes very much a lot more dangerous. A verdict has been reached in the case. We have not heard the verdict yet. They're basically gathering everyone before they read the verdict. We just don't know how quickly that's going to be, which is why I started the chat up now. And you know what? It is possible. The crime. If he commits any other crimes, comes out to a protest and starts trying to beat people again, um, then that will be, they will look back at these charges, and that actually enhances the sentencing. Yeah, I can't say that this will reform him, but if he doesn't change and continues what got him into this situation, it will not go well for him. Uh, when did I learn? I mean, I started the stream like I started sending messages within 30 seconds. I got the email at 10:41. So yeah, they wouldn't want to let the victims know. I've already spoken to the other victim. He is busy right now, but has asked me to, you know, keep him in the loop with what happens. Um, Now, I can't speak as clearly to Tiny's case because I wasn't following that as closely, but when he violated his probation, one second here. Okay. When he violated his probation, he went to the judge. Oh wow. Um, uh, yeah, I was about to say, I don't think you want the camera pointed there. I think the court just accidentally gave us a view of a juror. At least they're back. Anyway, um, when he violated his probation, he went back before a judge who revoked his probation. Um, but because of time he had already served and he was eligible for credits, um, basically like some form of good behavior. I don't get. I don't fully follow all of that legal the laws on that yet. But his probation ended, or his probation was revoked. He was sent to jail. They realized that probation didn't do him any good. He was released from jail mid-December, and at that point was completely free and clear. No probation, no parole, no nothing. Um, and then, of course, he went right back to what he was doing. I've heard that at the time he got shot up in Seattle or Tacoma, that he actually has a warrant out for his arrest from in Washington from January 6th. Unfortunately, I don't have the court record access that I do in Oregon, so it's a lot harder for me to follow along with something like that. But I'm sure the DA there, whenever the warrant finally gets addressed, will be referencing his assault charges in Oregon. Um, and actually, I can look up his case there. Search the wrong name. I think it's too soon. Oh, Olympia. I keep having problems spelling his name to look up the court record, but I've got it here. So okay, let's try this again. Okay, yeah. Also, his charges from 2018, he had two assaults in the fourth degree and an assault in the third degree. Um, Fourth degree is actually one of the charges that Swinney is being charged with here for the macing of that one protester. And assault in the third degree, while it is a felony, it's it's not one of the ones that is a Measure 11 in Oregon. That starts with assault 2. Uh, I don't. I have a feeling they're not allowing
Go ahead. You're done, Mr.
Reed Schweitzer for the state, SCHWEITZER. My bar number is 191962.
All right. We have been informed by the jurors that they have a verdict. We will go get the jurors and accept the verdict. Obviously, no matter the jurors' verdict, I expect all in the courtroom to comport themselves appropriately.
It sure sounds like there might be other people in the courtroom. Um, let's see here. I need to. I'll be honest. This is the first felony court case. That pop up is so annoying. This is the first felony court case that I've ever actually gotten to witness the verdict for. Um, I They may do sentencing at a later day to
All
give
rise for the verdict.
the state and defense chance to make cases for why they feel a particular sentence should be imposed.
Everyone may be seated. Good morning, members of the jury. I believe I see a verdict form there in the back row. If Mr. Keenan would please collect that. Members of the jury, what I'm going to do is as I review the verdict form, I will ask the presiding juror if a certain number of jurors agreed to the verdict. Assuming he says yes, I will ask you by show of hands if you agree with the verdict. So, with regards to count 1, attempted assault in the 4th degree. It was unanimous. Count 3, attempted assault in the 2nd degree. The jury has voted guilty. Was that unanimous?
Yes, it was.
Show of hands. Hands are raised. Count 4, unlawful use of a weapon. The jury has voted guilty. Was that unanimous?
Yes, it was.
Show of hands. All right. Count 5, assault in the 2nd degree. With regards to the theory that Mr. Swinney intentionally or knowingly caused physical injury to Jason Britton by means of a dangerous weapon, the jury voted not guilty. Did 10 or more jurors agree to that?
Yes.
Could the 10 or more jurors who voted not guilty please raise your hands? It appears that all 12 have raised their hands. With regard to what we will call the transferred intent theory, the jury has voted guilty. By show of hands, please indicate your vote. All right, they voted unanimously on that. Count 6, assault in the 2nd degree with regards to Megan Stewart. The jury has voted not guilty. Did 10 or more jurors vote not guilty?
Yes.
All right, by show of hands, could 10 or more of you who voted not guilty please raise your hand? All right, that was unanimous. Count 7, unlawful use of a weapon regarding the paintball gun, guilty. Was that unanimous?
Yes, it was.
All right, if everyone could please raise their hands who voted guilty. All right. Count 8, unlawful use of a weapon with a firearm regarding the revolver. The verdict is guilty. Was that unanimous?
It was.
Would everyone please raise their hands who voted guilty? All hands are raised. Regarding the special question, did the defendant use or threaten the use of a firearm during the commission of count 8? The answer is yes. Was that unanimous?
Was.
Would all jurors voting yes please raise your hands? All right. Count 9, menacing. The verdict is guilty. Was that unanimous?
It was.
Would all jurors please raise your hands if you voted guilty? All right. Count 10, pointing a firearm at another. The verdict is guilty. Would all jurors, was that unanimous?
It was.
Would all jurors please raise their hands? All jurors have raised their hands. Count 11, unlawful use of mace in the 2nd degree. The verdict is guilty. Was that unanimous?
It was.
Would all jurors please raise your hands? Okay, thank you. And last, count 12, assault in the 4th degree. The verdict is guilty. Was that unanimous?
It was.
Would all jurors please raise your hand? All right, I will receive this as a lawful verdict. Members of the jury, I thank you very much for your patience with us. for your attention during the course of this trial. I'm going to have Mr. Keenan take you now back into the jury room. Please take any belongings with you that you left in the courtroom this morning. If you have a few minutes and you want to stick around, I will be able to pop back and get feedback from you. On the other hand, if you've had enough of this building and you want to get on your way, I completely respect that choice as well. We will be sending you a letter. It will have my email address. If there is feedback you'd like to provide, even in sort of hindsight and upon reflection, please feel free to email me at any time. Thank you very much for your service. All rise.
I'll come back and talk to you.
All right. Excuse me. Sounds like there's some question about victims. What is the defense position?
We're going to exercise our right to delay sentencing.
Okay.
Yeah.
Is there a request for a pre-sentence investigation by either side?
Not at this time.
Okay.
We'll have to talk about that.
All right. Mr. Vasquez.
Yes, Your Honor, the state would request a pre-sentence investigation.
Okay. All right. When Mr. Keenan gets back, I think there's extra paperwork to fill out for that. Under the circumstances, does anyone have a sense of how long PSIs are taking right now?
I don't. I haven't had one recently.
Okay.
Perhaps what we should do is set this for a further proceedings in front of our status in front of Your Honor in about a week or 2 weeks and see what the parties think in terms of time.
Okay. All right.
For the state.
On October 22nd, the court has availability at 9 or 9:30 or 11:30.
Any of those times. Well, Ms. Desai, are you?
What day?
October 27th on the
22nd, 2/2.
Wow, I wrote 12/27. 10/22 in the morning.
9, 9:30, or 11:30. I am also open in the afternoon. Wide open in the afternoon.
Give me a time.
22nd, that works. 9:30.
Anytime.
9:30? 9:30, 10:22, further proceedings. So for anybody listening in, that will be really just a status check, a procedural matter. We won't make any major decisions on the 22nd, so I would not anticipate a need for live stream or observation rooms on that date.
Yep.
And then we will set a sentencing date at that time. Is there a special form for PSIs?
9:30.
Yes.
So,
9/1.
okay, so we're doing 9:30 on 10/22 as a status check for the proceedings to set a sentencing date once we have a sense of how long a PSI will take, but the state is requesting a PSI.
Yeah, I think for in custody, I mean, usually it's 30 days, but
Right,
I
I
don't
just
know how
don't know
things
what's-
are going
Right,
right now.
that's the concern. Well, let's do the minute order now. We'll find the PSI form and get working on it. If I need information from the parties at any point, obviously I will reach out to you and we'll get that filled out and signed as well.
I guess my only question is, Mr. Westover, will you be handling it?
I believe so. There was a waivable conflict that was waived for the purpose of trial. I'll have to double check and make sure that's not going to be an issue at sentencing.
Okay, I know on the form there's attorney and phone number, so I'll put both of you, and I'll put the Metro phone number, and,
Thank you.
I'll stay on this case, obviously.
for sure, yeah.
Mr. Vasquez, did you have a question?
No.
Oh, okay, I thought you were. All right, Mr. Swinney, I will see you back here in a few weeks. And we'll figure out next steps. Okay, sir?
And as I discussed with the parties in the court, I will download the exhibits and bring them for both the state and the defense. If the defense would like to, I'm happy to have them look that over before I turn it into the court.
And I do think we still need to provide to the court a formatted version of defense proffer A through court exhibit A through D or E.
Okay.
Oh, yeah.
We'll make sure the court has those before we're.
All right, and then we also have the reserve officer personnel files kind of just sitting here that I assume we need to.
And so the court's aware, those were ones that the state had requested, and we may discuss this off the record. The state had subpoenaed those into court as cross-examination materials on a potential defense witness that was not called as a witness in the trial.
Yes, thank you.
Did these, so they probably just need to go back to the
File room. Okay.
Thank you, Your Honor. Have a nice morning.
Thank you. All right. Are they in?
Yeah, I think so.
Okay, they just went off the record, which means they're going to shut down the stream here in just a second. Okay, so I am definitely going to need to watch. Yep, there they go. They killed the stream. I'm definitely going to need to watch for that minute order to show up. Once they get it into the court record. My understanding is that the initially both of the assault charges he was found not guilty as written, but looking at the charge of the assault against Jason Britton, they brought up the concept of transferred intent, which was Swinney claimed that he was aiming at the person behind Britton and just happened to shoot the wrong guy. So he wasn't intending to assault Britton, but because of his basically change in target, it looks like they said that he was guilty of assault by the theory of transferred intent. If I followed everything right, the only thing he was found not guilty of was the assault against Meg Stewart, and honestly, I think the only reason for that is I think the defense bought the idea that he didn't have that color paintball in his gun. I feel like it's questionable, if he didn't clean his hopper out, that he still had blue paintballs in there. How do we know he didn't have other colors? But that would be speculation, so it wouldn't have been allowed as, as evidence, I'm sure. Well, yeah, so there is going to be a status hearing in 2 weeks where they're doing some sort of investigation, probably trying to look more into Swinney's past records, interactions with law enforcement, things like that, to figure out what kind of sentence they think is reasonable. But since they don't know how long that's going to take, because with COVID they've been pushing out so many criminal cases that the timelines are all messed up from how they normally are. I mean, being I don't know that it's necessarily a legal defense, but because, like I said, the way that I heard it, he still did the assault. He still got found guilty. He just intended to assault someone else. Um, but yeah, in 2 weeks we'll have a better idea of we'll have um, when we'll have the actual sentencing. I did some deep dives, and I tried to put together some notes last night. I'll throw them up here on the screen. I don't know that they're going to be uh, necessarily useful for people because of it is kind of legalese jargon junk, but um, let me see what I can get here. Okay, so yeah, when uh that's part of what I was trying to figure out last night. There were a few things I looked at. The state uses a sentencing guideline, which is basically it's a two-dimensional chart where on the top they look at past criminal records, and based on what I know, no, we won't have sentencing in 2 weeks. We'll have a better idea of when we have sentencing in 2 weeks, but we won't have sentencing then. Um, anyway, yeah. Looking at the only past criminal history I know of is um his DUI in Texas. Oh yeah, he was definitely found guilty on almost everything. Um, so yeah, but yeah, according to the state, it looks like his criminal history is in a G column. Um, Charges he was acquitted of. He is definitely acquitted of one of the assault in the second degree charges. There's been some debate if he was acquitted of both. I think, from my understanding, he was charged with the one against Britain. It was just not a direct assault. It was because he was intending to assault somebody. Um, yeah. Um. So yeah, looking at some of the severity stuff, the like the unlawful use of a weapon charge. Um, those would normally be looking at like 3 to 6 month sentences. We can kind of ignore those because he's already been in a year. We can also ignore all the misdemeanor charges because those have a year maximum. Um, The attempt to commit assault, which was the charge 3, that one, what I saw was a suggestion of about a 2 year sentence is possible for that. His pointing a firearm at another one is basically a fine at this point. So a lot of the sentencing is going to come back to the assault in the second degree charge. Mandatory minimum is 5 years and 10 months. It could be more. It could theoretically be less, but I feel like, with all the circumstances, this is going to be on the higher end. Yeah, we definitely won't know anything for a while. We just do know that he has been found definitely guilty. He is not getting out of jail today, no way, no how. We just won't know for a while how long he's going to be in. Yeah, the assaults are on video. The problem is the defense. They raised a defense that Swinney was not the only one with a paintball gun that day, but his paintball gun was based on testimony by Chris Bailey. He was given green paintball, or no, orange paintballs, and the picture of Meg's jacket looks like a yellow paintball hit. So they're basically trying to say he didn't have yellow paintballs. It couldn't have been him. It had to have been somebody else. I've been hearing in the chat, or in the no, it was Mr. Vasquez that countered that the other person who had a paintball that day, their gun was jammed at the time that Meg got shot, so he couldn't have. There couldn't have been another shooter. So all that being said, if there is the minimum, that's what's going to happen between now and then. The defense is going to try to make their case for why going into the trial he was presumed innocent until found guilty. Well, now that he's been found guilty, he could have a change of heart on his. He could have a change of heart on his views on what happened. He could say that he's remorseful for what he did, that he wants to change. Whether it's real or theater, we would never be able to prove. But both sides will be able to get information and make cases trying to explain why they think they should go for a particular sentence. I think usually prison sentences are served concurrently, which means at the same time instead of consecutively, which would be one after the other. Oh yeah, and upward departure from the guidelines too. Yeah, definitely. I think upward departure makes an appeal more likely. I mean, not that an appeal isn't likely already, but yeah, this is. I used to bring up the reference to Jeremy Christian as an example of even with abolition there are still certain people who are not safe to try to rehabilitate in the community, and it's hard to say how do you remove a carceral state while still protecting the public from people who are proud of the crimes they committed. yeah, that's just this is definitely. I will at least say this much. I imagine there is going to be much celebration in the streets tonight. I will also suspect um, that there are going to be a lot of people looking for some sort of revenge. So everyone, be careful out there. Oh, right, right. No, yeah, no. The current system, I agree. It's not rehabilitation geared. Um, but the idea that I usually hear and I like is that a replacement for a carceral system has rehabilitation within the community. Then I look at Jeremy Christian, where when we were getting victim statements for his sentencing, he yelled at one of his victims that he wished he had murdered her. He was already convicted, and they had to remove him from the courtroom because of his outburst. And that's one of those things. It is the extreme case where you have someone that apparently will never be able to be rehabilitated no matter how much you want to try. Oh, no, not a problem. Yeah, I just, yeah, I don't think any of them follow me, and I don't know if anyone else got a chance, with how quickly this happened. Exactly, Cersei, and that's where my question has been: is how do you identify those people who cannot be rehabilitated in the community, and how do what is the most humane way that you can keep the community safe from them? I think that's the best way I can phrase it. And I do think his vigilantism statements on the stand are definitely going to play into his sentencing. I think, if he tries to make any claims that now that he's sorry for what he did, the state's going to call it as the bullshit that it most likely is. Whew. Uh, yeah, that is. Well, no, and the carceral system and the law enforcement system that we have, I definitely see that they're both issues. I mean, I will admit I am not as much of an abolitionist as some of the people that I interact with in the community are, and I recognize that it's a difference in view between them and I. Um, I do think that the amount of reform that we need might as well be, abolishment of the current system, but it does need to be replaced with something that does have law enforcement for these edge. I see. Jeremy Christian, Alan Swinney. These are the edge cases. The reason why we need to have something, but the vast majority of what's out here, we don't need the systems that we have now. And that's what needs to be changed in my view. But yeah, that is if we don't have any more big questions about the about this case here for now, I think we can go ahead and get ready to shut down the stream. And get a little bit of medication and me try to enjoy the day. The cat's home. Swinney's going away for a little while. This particular story is almost behind us. I'm definitely going to be following the sentencing phase of this. I don't know that there's going to be circumstances for me to do live streams because I might actually be in the courtroom for those hearings. At least for the status hearing, I will either listen in by phone or show up for the in person just to get an idea of when they're planning everything. Oh, God. While I appreciate the idea, Hannah, give you an idea of how much of a lightweight I am. One pull from an oil pen is enough to couch lock me for 12 hours if I'm not careful. So, yeah, one of the next cases that I'm looking at following because I know that there is a hearing coming up on Thursday. It's definitely not going to be anywhere near as interesting as this, but it's a public records case where Alan Kessler has been fighting against the city for getting identities of cops from during the protest because they were covering up their name badges and hiding their badge numbers, so we couldn't identify who was beating the crap out of us. Well, I thought I would get away with only having to mute one person. So yeah, be safe, take care, everyone. And if you want to stick around in the future, like I said, things will get boring again for a while, but I won't be streaming the status hearing in 2 weeks. It sounds like they're not even going to bother turning on WebEx for that. Also, I'd have to get permission from the judge to stream future hearings. But in 2 weeks, all it's supposed to be is, okay, here's where we are with the investigation, here's how long we need. And then hopefully they'll be able to set a sentencing date. And then we'll come back and then actually have the sentence and get the arguments and everything going forward. Once we know the date. Oh, God. Oh, DJ Elrad. Oh, you're killing me here, man. This has been declared a lawful protest. Yeah, I may try to ask about possibility of recording or streaming the sentencing and see what the judge has to say. But I'll broach or I'll cover that bridge, in a couple weeks once we hear what's going on. Yeah, the district attorney's office. I mean, they tend to get more resources than public defenders on a national level. I can't speak for Portland specifically, but district attorneys tend to be pretty hard. Um, which video has the 12 testimony? I'm not sure what you mean by the 12 testimony. Oh, duh. Um, there are a few, a few cop testimonies. I might have just gotten the last of them up on the channel. Let me. Oh, they convicted. They definitely convicted the lesser assaults. The only question we have is if the assault charge against Britain was an actual conviction. I think it was there uh, by a manner of transferred intent. There were some other people who thought that it might not have been because there were two ways they could find him guilty on that one, and they found him not guilty on one way. Um, yeah, let me pull up the. So yeah, I've been. I'm dropping a playlist in the chat here. Um, and I know the Brandon Combs testimony is a cop. Katrina Ensley is a cop, and Peter Braun is a cop. I think those were the only three cops that we had testify in this case. And all three of them, there are snips of their testimonies in this playlist. And Beta, if I recall, aren't your charges federal? They tend to be even harder on a federal level. Oh yeah, and as far as videos that I put up, I was actually just this morning I uploaded like 10 different videos. There was a problem with my scripting. Oh, they are state. Okay. I I don't really know. Unfortunately, I don't know enough about your case either. Well, but I think him shooting Jason, all it was I, yeah. You know what? They did try to throw out the transferred intent idea that was something the defense tried to do, which to me would have been insane. Like, oh, you can't convict somebody of assault if they assaulted the person they weren't planning to. From what I am seeing, yes, Swinney is guilty of one Measure 11 charge, which under statute is a 5-year, 10-month minimum sentence. Now, he already has a year time served. He could be eligible for credits. Um, oh no, you're fine. This was all very short notice, like freaking out short notice. Okay. Let me go ahead and let me try to zoom in on the charge list that I made last night. There we go. Okay, so the first one, the attempt to commit a Class A misdemeanor, was reference to an assault charge. He was convicted of that. Using mace in the second degree, he was committed of that, or convicted. Attempt to commit a Class B felony, that was an assault charge. That was it would have been an assault in the second degree, which was his first felony. He was convicted on that. Unlawful use of a weapon was a felony. He was convicted on that. Assault in the second degree. This first one is the one that we've had some debate about, where he was found not guilty, but under the transferred intent standard, he was found guilty, and that's a Measure 11 charge. The second assault in the second degree, which was the assault against Meg Stewart, he was found not guilty. Two more counts of unlawful use of a weapon, he was found guilty of both. And those were 5 out of 6 of the felonies he was up for. The menacing charge, he was found guilty. Pointing a firearm at another, which is a special misdemeanor, he was found guilty of. Another use of mace in the second degree, he was found guilty of. And assault in the fourth degree, he was found guilty of. So it's looking like 6 misdemeanors and 5 felonies. And one of them has a mandatory minimum sentence. I really don't expect OECI to have anything yet, but it's always worth a shot. Oh, ooh, there is a 11-page memorandum. Defendant's memorandum referencing transferred intent. Um, okay. Okay. Yeah, so I'm going to have to do a closer look at this document. And just try to throw it up here, or at least the header. No, I don't want it. Stop trying to snap. Here we go. So there is this defendant's memorandum regarding transferred intent, which was filed on the 3rd, and I believe one of the other days we heard hearings about it, either before or after court. I want to say this was like Friday afternoon, where the defense was trying to make the idea that you can't transfer intent from one person to another, where in this case, Mr. Swinney admitted he intended to shoot the person behind Britton, but then shot Britton. So at that point, that's why there was the question of the transferred intent, because that was not what he intended, but he still did an assault. As far as Measure 11 being trash, I do tend to see why that is problematic. Yeah. Yeah, I saw somebody else mention Booker v. Washington. One second, I can fix this. Yeah, this was self-defense claims were actively rejected by the jury. They looked at the evidence and said no, he was not acting in self-defense. If he had been acting in self-defense, they could have found him not guilty. So, no, to say that he was justified has been adjudicated as not true. But yeah, I'm gonna have to go through and take a closer look at this. But I think with the way that Measure 11 has been modified a number of times in the 25, 30 years since it was signed, it may not have the same weight as state case law. That said, I totally anticipate there's going to be attempts for an appeal on this. We do know that Mr. Westover is getting permission because he's no longer working with Multnomah Public Defenders. That he is working to get permission to remain on the case for the last hearings on this. So I don't know who would handle an appeal, if anyone will. That is something I will also be keeping an eye on, because if that happens, then that'll be noted on the court record, and then I have access to the appellate court docket. I still don't know yet how to sit in on those cases, though. So yeah, that's something else I've been wanting to learn, but haven't had the opportunity yet. That said, though, I'm going to go ahead and shut down the stream. Thanks for everyone coming in to sit in with me.